Hi, Dustin. My name is Greg Warder. I am honored that you called and asked me to participate in this, or that you sent me an email and asked me to participate. And my topic is negotiations contracts. Is your contracting process wasting time and causing your organization to miss critical opportunities? Is there effective alignment of the business? And can legal turn contracting into a competitive advantage? Once again, my name is Greg Warder. I'm the Vice President and Chief Contracting Officer for Diebold Incorporated. I've got a background in supply chain management. I got a degree in supply chain management at Miami University in Oxford, Ohio. I have an MBA from Kent State University. I have a JD from the University of Akron. Miami is one of the first universities to offer a purchasing supply chain degree. Miami's program is an outstanding program. I had excellent training. I feel very blessed by that. Started my first job at Diebold Incorporated. I was surrounded by outstanding leaders. One of my early bosses was a gentleman named Tom Loeb, and he was rated in Supply Chain magazine as being one of the top 10 most difficult individuals to negotiate with on the supply chain side, and I learned a ton from him. As my span and scope of responsibility increased, I increased my passion for the field and really enjoyed negotiating. I had a fantastic opportunity to do many things in my supply chain role, setting up global supply chains, setting up change management processes, global cost reduction processes, various forms of development, and this led to just a massive amount of contract work. I understood negotiations very well from my training and my business background, and of course, my MBA along the way there. But I became increasingly frustrated by the length and the uncertainty of the negotiation process. It seemed like, unlike all the other business processes that I was involved in, which were going the way of lean practices and Six Sigma type practices, the contract process seemed to be almost accepted, one of the few practices across business and across industries that was kind of like a black hole that didn't seem to, no one seemed to focus on the importance of it, and that it seemed so broken. And part of the reason I felt that the legal team seemed to be very good negotiators and very knowledgeable, and the business teams likewise, very knowledgeable, but the two fields didn't seem to cross very well, and the business people didn't necessarily trust or want to get involved with the legal folks, and the legal folks vice versa, and it seemed like both within my company and all external companies I worked with and colleagues in different industries I worked with, we all had about the same problem. So that's one of the reasons I decided to go to law school, is become kind of an insider on the legal side and understand the ins and outs of the legal practice, so I could have a much better approach in improving the contracting methodologies. So I did. I went to law school, practiced law for 5 years, and then I assumed somewhat of a blended role between supply chain, supporting the sales organization, so kind of both sides, the seller and the buy side, as well as the legal side. So I'd like to use that to kind of form as a framework to kind of walk through some ideas. One of the things, Dustin, you and I exchange ideas on is, can you talk about harnessing the ability to set negotiation and contractual strategy? Not addressing specific strategies here, because each commodity and each project and each service and whatever the supply chain activity is, it could widely vary in the strategy. But I would like to talk about general concepts. And I think a couple realities, maybe 4 realities, might help set the stage here. Reality number 1, and we all know this, but once a contract comes out between the parties, it's usually very serious that a relationship is likely to occur, or at least the parties are serious enough to really start to spend some time and invest some money in it. So this is usually after all the sales pitches and RFPs and discussions and proposals and pricing and everything, then the contract comes out. So for major contracts, I suggest project management tools, whatever your organization uses, whatever you're comfortable using, but identify and communicate the team members on your team. Who from legal, who on supply chain, who are the stakeholders, who are the subject matter experts, who are the management escalation points and so forth for that project. It's usually quite easy to get the same list from the other side. If you're on the supply chain side, the seller is highly motivated to sell to you, and if you ask them to fill out that ahead of time, who their equivalent parties are, it's extremely helpful. Also, it's important to set a negotiation format and schedule. How often will we meet? Who's going to be present on those calls? Is it a full group? Is it a subgroup? Is it, are we going to be on the phone, some kind of web-based tool, video, in person? You change up the format depending on the type of discussion taking place. In other words, if you need to see the words on the page, maybe use some web-based tool. Maybe if it's just a deep discussion on one or two issues, maybe it's better to be in person or on video or something like that. So it can change, but I think it's very important to set that schedule. Also have regular status updates and communication and escalation paths within your organizations to make decisions quickly. And then set and track progress towards a decision point or an end date. So the constituents within the organization know where the project stands, how quickly it's going to be done. Reality number 2 is fail fast or complete the project fast. And by this I mean, once again, it's serious at the point of contract, and project management tools can really help set the framework. But how do you quickly get the parties to a point of deciding whether this is either going to work or not work? If the negotiation will be complex or custom, start with a term sheet or a basic overview or outline or objectives or something like that, bullet points even. And maybe it's 90-day payment terms are important to your organization, or maybe maybe there's some other strict form of way that you handle your confidential information or something like that, depending on the type of transaction. Well, get that out there early and find out whether it's going to be acceptable or not acceptable, or how much flexibility there is in those type of things. So rather than wasting time with a multi-page agreement, setting those expectations up front and then spending the time documenting, even referring back to those term sheets, where the management did buy in, it saves a ton of time, as I'm sure some of you have tried that in the past. I'm a big advocate on never sending out a standard agreement for a significant deal or project. Standard forms are standard forms, and they're great for the mass majority of your projects. But if it's something really strategic and important, before you send it out, take a look at it, double check it. Is this sometimes you only get one time to really ask for what you want for. If you want customized, you want a little bit more, or something's given a specific purchase is particularly important, document that up front. Even if it's not in legal terms or something like that, highlight some areas, add some bullet points that the parties are going to need to talk about the following things or something. Quite helpful and moves things along quickly. Reality number 3 is that wasteful contract negotiations harm our businesses. Each contract negotiation has its own risk-reward complexity factors. So the anticipated length of negotiation depends on the deal and the size, and so there is no right answer. Oftentimes I get the question, how long does a contract take? Well, you don't necessarily know. 6 weeks might be appropriate for one kind of deal, but that may be 5 weeks too long for another type of deal. So it all really depends. Project management really helps you set up the stage work. You fail fast and complete with the templates and the bullet points and the term sheets and everything. That helps you get there too. But also realistically assess your risk allocation. So on this reality 3, one of the big wastes is if the parties sit around and are stuck or just emboldened in their risk profiles and their risk decisions. If there is no flexibility, that needs to be set up front, kind of in the fail-fast kind of thing. But once the negotiation starts and get rolling, the team should have a pretty good idea within those boundaries of where they're going to end up. Who needs to be involved, what risk, best optimal, average outcome kind of scenarios are helpful there. But it's really important to understand the risk, what you're going to do, how you're going to handle each aspect. And I like to baseline the lost value for the supply chain organization. I see oftentimes a massive amount of consternation over an issue that might delay a contract negotiation several months, maybe even 3 or 4 or 5 or 6 months, depending on what the issue is. It ultimately may be a relatively important issue, but the real value and the real loss to the organizations, both the sell side and the buy side, is the failure to implement. So if there's a tool that's going to be implemented that's going to save, $100,000 a month, and there's some issue that's a very remote risk that the chances of it happening are 1 in 10,000, and the issue is delayed for 6 months while that's being worked through, then the organization's lost $100,000 a month for 6 months. $600,000 impacts both the buy side and the sell side. So I think it's very important to be realistic on these risks, assess them, try to quantify them, and just like any other project, ensure that the decisions are made quickly on a fail fast or decide fast and risk reward type analysis, and keep things moving along as best as possible, because the real loss in value is when things aren't implemented. Reality number 4 is our organizations believe the contracting processes are broken. Just about everybody I talk to in my industry and outside my industry, peers and colleagues, both on the supply chain side and on the legal side, say that the number one complaint that they receive is things are broken, it takes too long, it's disorganized, it's unclear, there's no communication back to management. It's critical that we report out. So communicate the teams, communicate how quickly, communicate escalations, make the management and the business units part of the process. Communicate your wins. Continue to sell the value, not just in the price of the part, but in the implementation and the timeline and the contracting value with respect to contract done efficiently, met our standards, released. It used to take us 4 months, and now it takes us 2 months, or whatever that approval process is. Show your work and show your progress. It's very important to communicate the successes to the leadership. Dustin, the third question that we kind of exchanged about is, what about managing risks and reaching solid, well-conceived resolutions? Having been on both sides of the business and the legal, I'm a firm believer that contracts are both 100% business and 100% legal. And by that I mean every aspect of an agreement or negotiation, including legal clauses, quote legal clauses such as infringement, indemnity, and limitation of liability, has a direct impact on the risk and business decisions. Likewise, pretty much all business terms such as warranty, pricing, quality, statement of work, and so forth have a direct impact on the legal network. So it's somewhat of a waste of time and certainly a waste of value in the negotiations team perspective if you take this issue and I'll take that issue and we'll work it together and so forth. It's extremely effective if the business teams spend the time to prepare and bring the legal counsel up to speed on the various projects. Likewise, I can't emphasize strongly enough that it's important for the legal colleagues to bring the business folks up to date on what they're concerned about in the project. Best practice on contract negotiations is if the lawyers and the business people are on exactly the same page. So when the other party's lawyer is talking about a business issue, which is quite common in these negotiations, the lawyer has just as much credibility and just as much passion about resolving the business issue as does the business person. So then you have both parties talking passionately about an issue, about the importance of it, moving forward, as opposed to handing off and say, you take this one while I'm writing emails or something like that, and then I'll take the next one. And it's very clear if everyone's on the same page. I've had the opportunity to form a team of business and legal negotiators who routinely work through complex negotiations. Experience has taught me the value of supporting each other with a deep understanding of the overall business. It's a measurable value when the parties are on the same page. And I've seen that close alignment and the value that it provides. The fourth question that we discussed is, why do you see the powerful alignment between supply chain, the business, and legal as a substantial strategic advantage? Competitors can clearly compete on the strength and efficiency of their supply chains. Whatever your particular field is, your competitors are basically refining, improving, and developing their manufacturer development, subcontractors, sales channels, tools, and so forth. they're doing the exact same thing that your organization's doing, and there's continued push for better pricing, higher quality, better performance, better capabilities, and so forth. And so what separates your organization? Well, you can continue to tweak and improve, which will always be the case. But even with perfect alignment on all the business side, one of the critical things that you can do as a supply chain organization is strategically negotiate. And if you can follow these basic practices that we talked about here, such as contract managing and figure out how to get to fail fast or complete fast and avoid waste, and make sure that your organizations are communicating your successes on the same page, working together both with the legal and the business teams. It's significant that the value of your organization can compete. If your competitor takes 6 months to negotiate with a contract manufacturer to build a product in a lower cost geography, and your organization can do that in 3 months, you're half the time, and you've got a 3 months advantage on your competitor. Once again, if you can do that well, speed isn't everything. Speed's important, but you have to do it right. So it takes that pre-planning and organization and alignment. But implementation to implementation time, you cannot recover that 3 months in any other way other than getting there quickly. And the negotiation is typically the barrier point, or the contract implementation and execution is oftentimes the barrier point in which you're competing with your competition. So I would highly recommend that that you think about this as a business process. It's just as much a business process as a legal process. And contract negotiations and contracts are, from my perspective, one of the few areas of business that has not been streamlined, leaned, improved, tracked. Even with contract management tools and so forth, it's still a means and method to move documents and exchange things back and forth, but it's not a cohesive, strategic way to build discipline into the contracting process. So thank you for the opportunity to participate, Dustin, and I really appreciate it. Thank you. Bye.